Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. You know, we talk about the divorce and custody work, and we talk about the process of getting it to the point where the court enters an order, okay? A lot of times that order results in parties developing a working relationship that really sees them through to the point where the kids are graduating out of the system. They're 18 years old, they're going off to college. Beautiful. And if that happens, that's fantastic. Sometimes it doesn't happen though. Sometimes when one person feels that they're getting the shorter end of the stick, they feel slighted by you, by the kids, by the system, by lawyers. You may be on the receiving end of some harassment, some abuse. The children may be harassed by your ex. And what are you going to do about it? Well, you have to understand one thing. The court doesn't live with you. The judge doesn't drive by your house every night to make sure everything's okay. The court never knows there's any kind of problem at all unless you bring it to their attention. They cannot resolve what they don't know about. They cannot solve a problem unless they know it exists. Which means if your ex is harassing you, let's say electronically, calling you all the time, calling you at 3 o'clock in the morning, calling to speak to kids deliberately, knowing full well that the kids are already asleep, and then berating you for not waking them up. These kinds of things are going on. You need to bring it to the court's attention. The best way to bring it to the court's attention and get some traction is to have your lawyer file appropriate motions seeking relief. The court can give all sorts of relief. The court can, for example, order that no phone calls should be directed toward the children after 9 o'clock. And that you can shut off your phone and not take calls from your ex. The court can certainly order that. The court can hold your ex in contempt for harassing you, for harassing the children. More importantly, the court can say, you know what? In light of your conduct, we're suspending your parenting time. In light of your conduct, we're going to do this and this. We're going to make your parenting time supervised, since you can't seem to be trusted to conduct it in a way where you don't harass your ex. You can't be trusted to pick up your kids without fighting with your ex in the middle of the street. We've seen enough of that. So the point is the court has the ability to do this, but won't know that it's necessary unless you bring it to the court's attention. And it may take a couple tries. The court is loath to suspend somebody's parenting time on the say-so of the other parent because the court knows that people play games. So it may be a situation where you file your motion and all the court will do is warn the other side and give them another chance to do the right thing and tell you, got to let me know if he does it again. And you may have to video these drop-offs and all that to bring the court evidence. To some degree, getting relief of this, it doesn't happen in one shot. It's like pushing over a pop machine. You don't do it in one shot. You got to rock it a little bit. It's maybe the same thing here. You might have to do this incrementally until you can finally get the court to agree that drastic action is required. And that drastic action may result in holding someone in contempt, fining someone for costs and attorney fees, sanctioning them, suspending their parenting time. If you have any questions about your case, though, reach out and we'll be glad to help you out.